Amongst the variety of draconian legislation that has shrunk the democratic space in Pakistan, especially in the past 10 years, ever since Nawaz Sharif Operation Get Nawaz Sharif was first started and the Panama Leaks most has been the Pakistani Electronic Crimes Act. And it was tabled, ironically, by the same people that it was used the most against. It was tabled by Anusha Rahman under the guise of it being an IT-related law, because at the time we needed to police cyberspace and we didn't really know what we were doing. And it became the bane of the PMLN's own existence, and it was used widely to crush any dissent that was coming up with regards to what the what was being done to the PMLN. And later, when the PTI came into power, it duly strengthened this law further, and equally unironically, it was then used against them with the same effect and is being used today. It is part of the pantheon of Pakistani laws that can be considered not only anachronistic but also imperfect, both in their creation and even more imperfect in the way they're being used. I think the way this law came about in itself was a very troublesome environment. So there were plentiful excuses used to bring about this concoction of a law that we do need an update, or we did need at the time an update in how electronic crimes are investigated, the powers of investigating agencies with regards to offenses on the internet, with regards to offenses regarding cybercrime. And it was under this guise that the PECA was first tabled and conversed about. And then along came this idea that, there is also a dire need to prevent child pornography. So that was also clubbed into the act, which could have been a separate and much more sharpened area of legislation. Then it was decided that women are being harassed and blackmailed through forced pornography or the use of their explicit photographs and content, and that also became a part of this act. Now, ostensibly, this is all an electronic crime, but it becomes a very obtuse way of legislating for electronic crime when there is a single act of parliament that's talking about doxing, that's talking about internet capture of resource, that's talking about illegal domain capture, about illegal data capture, and at the same time is talking about child pornography and talking about harassing women and illicitly without their consent sharing their images. So in terms of best practice, this would normally be legislated independently. But such was the push and such was the need for from the relevant quarters, the need for coverage for investigating everything related to electronic crime, as if the internet, the universe of the internet and the universe of the digital universe was something so alien that it needed to be captured in summary terms, that we got this one act. And then instead of it being whittled down and practices leading to it becoming more refined in each area that it covered, it was broadened even further, where really the only two places of note that PECA was used was with regards to women being harassed regarding their private content, and journalists, which wasn't even really envisioned to be within the realm of what the act was being legislated for. It just went on to speak of, in section 20, an area of law which covered the use of online space and tried to monitor and regulate it, and that was used to try and prevent journalists from speaking. And then it was further strengthened in Imran Khan's government, whereby the idea of reputational harm was also brought into PECA, effectively rendering it a Defamation Act plus. And Justice Atul Minilla, as he then was in the Islamabad High Court, rightfully struck it down. But the lingering effects of it remain, and Section 20, even though it is off the books, is still being used as a primary tool of harassment and coercion against people who operate online. Legislation needs to have a purpose to it, and legislation needs to be homogeneous and uniform. And just because certain things might overlap doesn't mean that you have to make an omelette of the law and present it in one document, because it doesn't really cater, it doesn't really serve the ends of legislating for a society. If you were to haphazardly bring everything within one code and then bring it about as if it is an answer to the developmental issues in relevant areas of law that exist already. So this offenses against the dignity of a natural person and areas with regards to people's privacy and the harming of that privacy, and could have been addressed better by reforming the relevant areas of the Pakistan Penal Code, and where defamation was concerned, by reforming the relevant areas of the defamation ordinance, and strengthening PEMRA to do their job, because the law does exist allowing them to afford the same protections. Similarly, with regards to evidence capturing and the core of the law, which was the preamble through which Anusha Rahman tabled this law, was that we don't have anything to effectively prevent cyber stalking, hacking. Well, then that could have also been added to your relevant Pakistan Penal Code, which would have been the right way to go about doing what you were doing. The relevant sections that relate to theft and consent could have been amended. The Qanun-e-Shahadat Act could and should be amended to include the capture of evidence electronically. This method of legislating via omelette making, which is that you leave a system rather than correcting the principal system itself and bringing it up to par and up to date, you instead afford new layers into the law, whether it is the anti-terrorism courts and the Anti-Terrorism Act, and then the banking courts and the relevant banking regulations. What Pakistan tries to do is, instead of fixing an ailing system, or at least trying to make it creak and work, we instead start adding layers on top of it. So you have an accountability bureau and accountability courts instead of fixing the actual existing mechanism of corruption and investigation of corruption. You have anti-terror courts because we wanted to put these people to jail and the system wasn't delivering them fast enough and they were extra heinous. Then you have, as I said, banking courts because banks weren't willing to operate in your environment because it was taking too long to recover money that they felt was due. And then you have the military courts that try terrorists, for which you create a sunset clause in your constitution because your system doesn't work. And in the end, what you're doing is the system not working and you're allowing for it to not really have to improve itself. You're just creating exceptions and special circumstances in which people can step in and say, anything can be terrorism just so that you can get to terrorism court. And that creates its own set of challenges. And that's the same thing with PECA, that it was an exception creation, a law created for an exception. And the majority of the exception it created, it's never really been used for. The sections that it pointed towards ostensibly to guard the dignity of people who were being harassed and molested online was instead expanded to a point of mutilation and used to stifle journalistic dissent. Speaking of the rules that have to go with the Act, and the rules have always been an attempt at making the Act even more draconian rather than bringing it within standard. And there are no really set patterns of rules with which the agencies that use this law operate. And that's part of the problem. So you have a bad law, at least you can, or you have a opaque law or a vague law, at least it can be structured via rulemaking. And I think I'm not up to date on what the standard of PECA rules is right now, but I do know that courts have on multiple occasions ordered for there to be a structured framework as to how you go about doing what you're doing with regards to PECA law, and specifically in the cases of journalists, because it is arbitrariness that suits these investigation agencies when they are using law to coerce. It is the allowance and arbitrariness allowed by the gray in the law that is abused, and such is the case that we've seen with prominent bloggers, prominent commentators, that they have been abused to a system of complaints pending by women, the majority of them being women or people who say they're being harassed online, they're being scammed, they're being extorted from, their privacy is being violated. And those complaints stay on the back burner because there is no systematic method to process those complaints in a teleological or chronological order. And instead you have these complaints that bear the interests of the state that jump this queue, and all of a sudden you have 5 hearings in a month for someone who is a journalist who is speaking against the way the grain of the country is running at the moment. So this is, in essence, this is an example of arbitrariness that could have been structured by rulemaking, but hasn't been.